Diana Romanowska, and I am a certified family law specialist practicing family law in the Bay Area, California. Today, I would like to talk about jurisdictional issues, venue, what to do, how to defend, where to file, how to file. First of all, in order to file in one county, and I'm talking about California law only, for dissolution of marriage, one party doesn't have to be one or the other, just one. Could be a petitioner or respondent. Has to be in the county, resident for at least 3 months, and living in California for 6 months before filing a petition for dissolution. Now, some people call me and ask, well, what if I went on vacation to India to visit my parents? For residency requirement, it is important what the intention is. Intention to be in California and to stay and live in California for 6 months. So, let's say petitioner filed in California, however, was not living for 6 months, and respondent knew about it. So respondent can defend the request that was served on respondent by filing motion to quash the proceedings, by saying, here are the facts. I know, I have personal knowledge, and then the court will set up a short cause hearing to discuss it. A second option is to file a motion to change the venue when respondent says, and watch out, respondent, by not making a general appearance, meaning not to file a response, FL 120. You're just filing a motion to quash and mentioning special appearance for this purpose only. Very important not to accept the jurisdiction by filing a wrong document. And so in the second motion to change the venue, respondent can say, wait a second, we live actually and used to live in, still living in this other county or this other state. That's why we're asking to change the venue. So improper venue needs to be raised right away, because once the judgment is finished without respondent's participation, through a default or whatever way, if the judgment exists, then respondent may not raise it as a defense. So that's venue. Now let's talk about jurisdiction. Jurisdiction can be a defense to a judgment for enforceability reasons. Enforceability reasons are important because in the judgment, the petitioner could say whatever he or she wants. I want this house, full custody of the children, and then you have a judgment. How do you defend yourself? So it's important to know the jurisdictional issue is a defense. When the court does not have jurisdiction over respondent, meaning the other side who has been served with the petition and summons and potentially RD form, whatever forms, when the respondent has absolutely no contact to, it's called forum state, meaning to the state where petitioner filed this petition. So, and the courts have actually looked at it, and this issue has been litigated for many, many times. What is minimum contact? And I wrote a list of examples of minimum contact. Presence in the state is considered as a minimum contact, meaning the respondent cannot say, I don't have minimum contact if the respondent is in the state. No defense to no minimum contact, meaning the respondent has to oblige with the state, and the court can decide about this case if respondent has been personally served in the state where petitioner filed the petition. I had a case where my client came to my office and said, we have this big company and he's in Philippines and he usually never gets in, and we were able to track him through bank transactions that she had access to see that he was in a hotel. So we sent a process server to serve him at 3 a.m. A process server was literally waiting all day all night to see when the respondent will come out in order to serve, because the respondent would leave the country right away. So that was a big deal, and minimum contact is very important. Ownership of a house, car, citizenship, doing acts elsewhere that have effect in California. driver's license, tax records, such as tax returns. So that's considered a significant minimum contact. On the other hand, what is not significant minimum contact is, for example, if there was a case when father and his wife and two children lived in New York, and then father said to his wife, "I'm okay if you take the children to California and they can be there for a year for school purposes." That was not considered, and she filed for divorce. That was not considered as significant minimum contact of the father. So there is one exception that I didn't experience in my practice, but minimum contact cannot be raised as a defense in cases where father abandons the family in California and then they are falling on welfare. So that they can get divorced and he cannot raise that defense. Now, what can respondent do if either it's an enforcement of a judgment issued that respondent is fighting against? There are several options. First, motion to quash service of summons. That's, again, watch out, respondent, for not filing FL 120. If you do it, the case is over, you accept it. It's called general appearance. The case is over. California has jurisdiction over you. So do not do that. File a motion to quash service of summons. Appeal the judgment on jurisdictional grounds. It's code section CCP 418.10. CCP meaning Code of Civil Procedure. Separate motion to set aside a judgment. Assert judgment invalidity as a defense of an enforcement. And if you would like to read about everything I talked about personal jurisdiction, it's also in code section CCP 410.10. I think that's all I have for today about the venue and jurisdiction. Please remember to like the video, subscribe, and if you have any comments, ask them down below, and I will see you soon. Bye!